Jonathan Lederman from LSS Law, and I'm here to answer a very frequently asked question, which is, what would my Chapter 13 plan payment be if I decide I want to file a Chapter 13 bankruptcy? Now, I'm going to get into the weeds a little bit here, but don't worry. To figure out your Chapter 13 plan payment, it's going to be a comparison of what the creditor would receive if you were in a Chapter 7 liquidation bankruptcy versus what your disposable income is household-wise from a bankruptcy court's perspective. And whichever of those two numbers comes out higher is going to determine what your Chapter 13 plan payment is. So I'll try and be really quick about this just because I'm asked all the time. But one aspect of it is we will get a personal property inventory from you and figure out what the value of your non-exempt assets are, and we'll put that off to the side. Let's just say that's $10,000 for today. Secondly, I'm going to have to plug in some information into a form in my bankruptcy software that's going to look at what your household's income has been for the previous 6 months. And if you are over the median income for the household of your size, at the end of that exercise, the software will shoot out a number. And I will have to multiply that number, which represents your disposable income from a bankruptcy perspective, for 1 month. I'm going to multiply it by 60. Let's say that number was $1,000. So now if I multiply that by 60, we're talking $60,000. I compare that to the $10,000 value of your non-exempt assets in the Chapter 7, 60,000 is more than 10,000. So that's what your creditors would have to get. And we would divide that payment by 60 and make sure that the trustee gets her 10% trustee fee. Now, if you're under the median income, and I do that same exercise, the result is not going to be a number. It's going to say that your payment from a disposable income perspective has to look at what Schedule I minus Schedule J is, which is figuring out your budget on the day you're filing bankruptcy and looking forward. It's not looking backwards like the other form was. Again, this will give me a number, and this time we're going to multiply it by 36 since you're under the median, and we'll compare that number to the same 10,000 we were talking about earlier, and whichever one's higher is what your creditors will get. Now, I know that was a very complicated explanation, and the point is you don't really need to know all of these details. Rest assured that when you hire myself or my law firm, I get all this information from you, I plug it all in, I get the answer, and prior to filing your case, I will explain to you in plain English what your payment will be. And at that point, you have an opportunity to react and say, great, I know I can afford this payment, let's go forward with the Chapter 13. Or, you know what, this is going to be a problem, maybe we need to wait, maybe Chapter 13 is not for me, but we will figure that out together before it's too late. We will never put you into a Chapter 13 in circumstances like this until we know what your planned payment will look like. If you're ready to take the next step and to schedule a consultation with myself or one of the other attorneys in my office, please know that we offer a no-cost, no-obligation bankruptcy strategy session in which we go over your goals and your options, both in and out of bankruptcy, and help you make an informed decision on what will be best for yourself and your family. If you're ready for that, contact my office as soon as possible. If you're not quite ready for that step and you're simply looking to gain access to some additional resources or watch some other videos in which I answer additional frequently asked questions, links to those appear below. Please remember, doing nothing changes nothing. I can't encourage you enough to at least take some action and figure out what's best for yourself and your family. Reach out. I'm here, ready, willing, and able to help when you're ready. Please call.